Masson vs. the State of Queensland follows an allegation of medical negligence by a Queensland ambulance service paramedic when responding to the call by Miss Masson, the plaintiff. Miss Masson was suffering a life-threatening asthma attack and collapsed on her friend's front lawn. The senior attending paramedic, Mr. Peters, administered intravenous salbutamol to achieve dilation of the bronchial passage and improve breathing. As a result of her asthma attack, Miss Masson suffered a severe hypoxic brain injury. The plaintiff claimed that the decision to administer salbutamol rather than adrenaline was negligent. This claim was dismissed on the trial but overturned by the appeal. This essay will critique the appeal judge's legal assessment of this claim and demonstrate that Mr. Peters was not negligent. Medical negligence can be defined as an act arising when a health professional acts in a way that falls below the standard care of a reasonable person. To succeed any medical negligence claim, the plaintiff must satisfy 3 criteria. Debate arises when assessing if Mr. Peters breached his duty of care. To assess this, reference must be given to the standard of care, which is a matter of medical judgment. By referencing Rogers v. Whitaker to assess Mr. Peters' breach of duty of care, reference no longer had to be made to what a reasonable, competent practitioner would have done. Unlike the principles of the Bolam test, where practitioners are judged against the standard proclaimed by their peers, Mr. Peters' standard of care was based on all available evidence. Consequently, Mr. Peters' standard of care was determined by medical specialists despite the appeal judge's acknowledgement that ambulance officers are not medical specialists. This made Mr. Peters vulnerable to a breach of duty of care and medical negligence. The decision of the Court of Appeal in the Ambulance Service of New South Wales v. Worley substantiates this reasoning. The trial judge found the treating paramedics to be negligent regarding their administration of adrenaline. However, the Court of Appeal dismissed this claim as was critical of the medical expert evidence used, as there were 5 experts in emergency medicine rather than paramedics. The appeal decision suggests that paramedics are vulnerable to negligence claims when their standard of care is determined by emergency medical physicians. The appeal judge in Masson v. the State of Queensland cited that the judgment in the Ambulance Service of New South Wales v. Worley can be determined that ambulance officers cannot be expected to make fine professional judgments which would require the education and training and experience of medical specialists. Despite this acknowledgement, the appeal judge still used medical specialist opinion to interpret the QAS clinical guidelines and flowchart to determine Mr. Peters' standard of care. This formed the judge's decision that Mr. Peters was negligent, as the medical experts disagreed with Mr. Peters' interpretation of the flowchart. Additionally, little consideration was given to what a peer professional would have done. The appeal judge disregarded a significant point by a paramedic, Mr. Canali, that many paramedics would have used salbutamol because the 2 drugs had been fighting each other over that pole position. Furthermore, the appeal judge stated that whilst there were credible views in 2002 favoring the equivalent utility of salbutamol, there was not what His Honour described as a credible body of professional opinion to that effect. Not only does this imply a distrust of the medical experts used, but that the medical body which supported the equivalent utility of salbutamol in 2002 was less credible than the opposed party. This does not adhere to the decision made in Maynard v. West Midlands Health Authority, where it is stated that a judge's preference for one body of distinguished professional opinion to another is not sufficient to establish negligence in the practitioner. Furthermore, as critiqued by the appeal in Ambulance Service of New South Wales v. Worley, no consideration of the CPM's language and medical experts' understanding of such guidelines was taken into consideration. Subsequently, the CPM was interpreted primarily by medical specialists who are unfamiliar with the CPM language and guidelines. Had this event occurred today with regard to Ambulance Service of New South Wales v. Worley and the current law following the Civil Liability Act of 2003, where the standard care is to be established by what is widely accepted by peer professional opinion, the selected medical experts in Masson v. the State of Queensland would only be critical care paramedics, and ultimately the outcome of the case would have been very different. An underlining fact that cannot be overlooked when analysing Masson versus the State of Queensland is the intention of the clinical practice guidelines. The legal decision making in this case was heavily influenced by the interpretation of the CPM, particularly the flowchart on dyspnea asthma, which was critical in determining whether the administration of salbutamol was negligent practice. However, a key fact that seemed to be dismissed by the appeal judge in his legal assessment was the intention of the CPM. The CPM states that it is designed to assist clinical judgment, and deviations from the guideline will occur. However, the appeal judge seemed to use the CPM as a prescriptive treatment protocol rather than a guide. A heavily debated topic in the appeal was the scope of discretion to consider adrenaline, which Mr. Peters did consider but chose to withhold initially. The appeal judge concluded by using medical specialists to interpret the flowchart that Mr. Peters was required to administer adrenaline, when in fact he was only required to consider administering adrenaline. While some may fault the ambiguous nature of the CPM, the appeal judge's use of it in his legal assessment completely disregards the CPM's purpose. This essay has demonstrated that the legal assessment by the appeal judge made Mr. Peters vulnerable to a breach of duty of care and therefore a medical negligence claim. Mr. Peters' standard of care was unfairly determined by medical specialists rather than peer professionals. Additionally, the clinical practice manual was not applied to this case in the manner that which it was intended, and therefore the legal assessment involved in Masson versus the State of Queensland caused Mr. Peter to be vulnerable to a breach of duty of care, and therefore he should not have been found negligent.